Like any other level of society that requires a framework for its legal activities and rules, there is a need to develop the same globally. International law fills the gap there and takes care of the regulation and smooth implementation of laws at the international level. Today's law is the product of hundreds of years of evolution and change. International law has types that distinguish it based on the areas that it is implemented. There are mainly three types of rules that are used on a global level, and it is public, private, and supranational international law, which will be discussed further in this video. Public international law refers to the rules and regulations imposed by government bodies on international relations between states and institutes. These rules are set concerning humanity, such as the ocean, human rights, international business, the environment, etc. Public international law is applied to organizations such as the United Nations, UN, and the World Trade Organization, WTO. It is also referred to as a conflict of laws. It was first stated by Ulrich Huber in his book, De Conflictlegum Diversarum in Diversissime Pares, in 1689. Private international law makes sure to set the deal with the relationship between the private entities of different countries. Legal action is required when people from different geographies converse with each other. A supranational situation arises when a state or country surrenders in front of any other nation's court of law. They give all the rights to that court to make all the legal decisions. These decisions are taken higher than the ones made by the national court. It is an important feature that keeps it apart from public international law. International law is comprehensive, having many sources that make it complete. These sources are the fields from which different rules of the law are extracted and implemented in international law. They can be carefully divided into two major categories, primary and secondary sources, which define their origin in nature. The primary sources of international law are formal and derived from official bodies such as treaties, customs, and legal principles. It is generally regarded as an authoritative statement of the sources of international law, and Article 38 has been treated as a standard, convenient catalogue of international legal authorities. It is one of the most important sources of international law. Whether general or particular, international conventions are established based on the rules expressly recognized by contesting states. Patterns can be multilateral or bilateral, based on their relationship with a treaty and the formulation of universal or state concerning laws. It is the oldest source of international law. The rule of customary involves a long history that has gained recognition by the entire race. Current customary international law sources can be educated from state practice as it is not a written source of law. Its standard features are uniform, general, duration, and law opinion. International law's most recent addition source to international law is the general principle of law. It is common to all legal bodies and applicable to the relationship states. The reason behind its provision is to ensure the proper regulation of the few decisions in international law than in a municipal system, as it did not have any ruling method. Article 38(1)d is part of international law's material source, also known as the secondary source. It states that judicial decisions and the teachings of the most highly qualified publicists from various nations also contribute to the formation of international law. Still, they are not binding and are only advisory. Under the judicial decisions subject to the provision of Article 59, the court can apply the previous choices, also known as the evidence of international law. These are implemented after the most highly qualified publicists from various countries have been implemented. Because they are the secondary means of determining legal rules. Other significant components of this source include the teachings of highly qualified writers such as Gentili, Grotius, and Vattel. They were regarded as the supreme authority on international law from the 16th to 18th centuries. Textbooks are used to determine the direction of any given topic rather than as a source of actual rules. Thank you for watching this video. After this, you will be able to perform well in your law studies. If you wish to see more videos on international law, subscribe to our channel, as we have many more educational videos coming soon.